Hi everyone. My name is Shazia Khan, and today's session is on criminal law, and we'll be doing learning outcome 4, which is to understand the general principles of incoherent offences. Now, in learning outcome 3, the last session, we looked at understanding property offences, and we looked at the components of property offences. We looked at the section 1, subsection 1 of the Theft Act 1968. We looked at the actus reus of theft with reference to case law, leading cases. We also looked at the actus reus for theft in regards to property and property belonging to another with reference to cases. Then we looked at the issue of mens rea of theft. We looked at dishonesty and case law with regards to this. We also looked at section 2 of the Theft Act 1968 and looked at cases such as the R and Feely case. We also looked at the actus reus of robbery and burglary, and also identified what dishonesty meant under common law. We looked at the Gosh test, and we looked at burglary and robbery as well. We looked at the actus and mens of robbery and the actus and mens of burglary with reference to leading cases. And we looked at the issue of burglary in regards to leading cases such as Collins, Aaron Brown and Aaron Ryan. We also looked at defences that were available for individuals, and we also looked at the issue of section 1, general defences, and we looked at fraud as well. Okay, now this session we're looking at learning outcome 4, which is to look at understanding the general principles of incoherent offences. So we will be covering the types of incoherent offences, explaining the meaning of assisting or encouraging crime, and distinguish intention to commit crime from an attempt. So 4.1, we will look at assessing the types of incoherent offences. So firstly, we need to identify what incoherent offences are, and then we move on to the types, okay? So incoherent offences just begun, undeveloped, and are incomplete. So these offences are where the main crime has not been committed. They are concerned with planning and preparing for an offence to be committed. So in a literal sense, the word incoherent means unfinished and undeveloped, as we mentioned above. These acts are not complete offences, as they are performed in the process of the commission of the final crime. So it helps or aids in the final crime. Features of incoherent offences. Preliminary. This is where incoherent offences penalise preparation, planning or encouragement towards the commission of a substantive offence, as we mentioned earlier. Freestanding, so these are incoherent liability, arises before and regardless of whether the substantive offence is committed. And then harmless wrongs, and hence it arises before and regardless of whether any concrete harm results. Incoherent offences refer to offences where D has not actually committed a substantive crime, but has done one of the following. So he's made the attempt to do something. So D has tried to commit the crime, but has failed for some reason to complete it. They entered into a conspiracy with at least one other person to do so. So, trying to identify and plan the crime. Assisted or encouraged someone else to commit a crime. Incoherent offences, the attempt. So the offence of attempt existed at common law, but is now regulated by statute. The Criminal Attempts Act 1981 stated under section 1, subsection 1, that if with intent to commit an offence to which this section applies, a person does an act which is more than merely proprietary to the commission of the offence, he is guilty of attempting to commit the offence. In regards to attempt, we're looking at the actus reus of attempt. Actus reus of attempt means that an action or conduct which is a constitute element of a crime, as opposed to the mental state of the accused. In the 1981 Act, it imposes liability on those to do an act which is more than merely proprietary to the commission of the offence, as explained in the definition. The judge must decide whether there's evidence on which a jury could find that there's been such an act. The test of whether these acts have gone beyond the merely proprietary stage is essential question of fact for the jury. And the leading case in this is the leading case of Anderton and Ryan, 1985. In this case, the defendant had bought a video recorder, but later confessed to the police that she believed it to have been stolen property when she bought it. The defendant was charged with attempting to handle stolen goods, although the prosecution was unable to prove that the video recorder had in fact been stolen. In this case, the House of Lords, by a majority of 4-1, quashed the defendant's conviction on the ground that she could not be guilty of attempting to handle stolen goods unless such property was shown to have existed. A majority of their lordships refused to accept that the defendant's belief that goods were stolen was sufficient of itself to result in liability. Such a result may have been in the aim of the 1981 Act, but their lordships felt that Parliament would have to express its intentions more clearly before the courts would be willing to impose liability solely on the basis of what the defendant had thought she was doing, as opposed to what she was actually doing. The other important case in regards to this is the case of Shivu Puri in 1987. In this one, the defendant was paid to act as drugs courier. He was required to collect a package containing drugs and to distribute its contents according to instructions which would be given to him. On collecting the package, the defendant was arrested by police officers, and he confessed to them that he believed its contents to be either heroin or cannabis. An analysis revealed that the contents of the package not to be drugs, but harmless vegetable substance. The defendant was convicted for attempting to be knowingly concerned in dealing with and harboring a controlled drug, namely heroin. His appeal to the House of Lords was dismissed. Lord Bridge said that in applying Section 1 of the Criminal Attempts Act 1981 to the facts of the case, the first question to be asked was whether the defendant intended to commit the offence. The answer was plainly yes. Next, did he do an act which was more merely proprietary to the commission of the offence? The acts were more than merely proprietary to the commission of the intended offence. So when we look at incoherent offences, okay, you have various tests for attempt act. So the substantive steps is that, did the defendant take substantive steps towards the commission of the crime that strongly corroborate with the defendant's criminal intent? The proximity is, how much did the defendant have left to do to commit the crime? Then we've got the elements of a probable desistance. How far did the defendant process towards commission of the crime? And res ipsa loquitur, and this is when the defendant stopped progressing, was it clear that the defendant had no other purpose than to commit the crime? So the attempt, mens rea of attempt. Mens rea is he had the intention or knowledge of wrongdoing and constitutes part of a crime as opposed to the action or conduct of the accused. The essence of mens rea in attempt cases is D's intention. So it penetrates liability for rape. It fails to penetrate not liable even for attempted rape. So I don't consent. I don't know whether she consented. So these are elements of mens rea. An attempt, when you look at mens rea, as an attempt is an offence of specific intent, it requires the defendant to harbour an actual intention to commit the offence in question. Anything less, for example, recklessness, will not be sufficient, even where it would be sufficient as the mens rea for the full offence. So, for example, recklessness as to causing GBH would be sufficient, for conviction under Section 20 of the Offences Against Person Act 1861. However, for the first purposes of an attempt, the recklessness would be insufficient mens rea. So for conspiracy, incoherent offences, conspiracy, where two or more people have agreed to commit a crime, then there may be liability for conspiracy. Gathering enough evidence to prove that the parties have agreed to commit a crime can present problems for the police, but where evidence is available, conspiracy is a valuable weapon for prosecuting those involved in large-scale organised crime. Until 1977, the law of conspiracy was a matter of common law. The actus reus of conspiracy. So the actus reus of a conspiracy is to complete as soon as there's an agreement to commit a criminal offence. This means that the parties must have reached agreement to commit the same offence. The leading case for that is the case of R and Taylor, 2002. Then we've got, if the parties have reached general agreement to commit an offence, then the courts may be prepared to overlook disagreements as to the details, as in the case of R and Broad, where D and E agreed to import Class A drugs. D thought it was heroin and E thought it was cocaine. It was held that it was irrelevant. Both agreed to provide Class A drugs. So conspiracy mens rea statute text. Subsection 1 states that if the agreement is carried out in accordance with their intentions, so in this one, so they must intend that the substantive offence is committed. Section 1, subsection 2, where liability for an offence may be incurred without knowledge on the part of the person committing it of any particular fact or circumstance necessary for the commission of the offence, a person shall nevertheless not be guilty of conspiracy unless he and at least one other party intend or know that the fact or circumstances shall or will exist at the time. And that includes in the diagram there that that's an offence that requires less than knowledge about the circumstances. For example, strict liability, negligence, rape, or the mere belief in handling. So to be guilty of conspiracy to commit any offences, one must intend or know the circumstances. Surely that's only true of offences that do require knowledge about the circumstances. Assisting. At common law, it was an offence to incite someone to commit an offence. The general offence of incitement was abolished by Section 59 of the Serious Crime Act 2007. Very specific incitement offences survive include soliciting murder, incitement to commit various offences involving production, possession or supply of controlled drugs, and inciting a child to engage in sexual activity. Liabilities under Serious Crime Act 2007. Section 44 to 46 of the Serious Crime Act 2007 create 3 new offences of doing an act capable of encouraging or assisting crime. The new offences require that the doing of an act capable of encouraging or assisting with the commission of, number 1, an offence with intent to encourage or assist, which is Section 44. An offence believing it will be committed and believing that the act will encourage or assist, Section 45. And 1 or more offences believing that 1 or more of them will be committed and believing that the act will encourage or assist, Section 46. These offences replace the common law offence of incitement, as we mentioned on the 1st of October 2008. They allow people who assist another to commit an offence to be prosecuted regardless of whether the underlying substantive offence is actually committed or attempted. So 4.2, explain the meaning of assisting or encouraging crime. So accomplice liability. An accomplice is to a crime is a person who becomes equally guilty in the crime of another by knowingly and voluntarily aiding in the crime of an offence. And that diagram identifies that. So you've got guilty of the crime, help another commit a crime, guilty of the crime, commits the crime. Here, you know, it is where the accomplice is helping another, and they face the same degree of guilt and punishment as the individual who committed the crime. Indeed, accomplices can face the same penalties as the person committing the crime, and include the same prison time as well. It is not always just the person that carries out the actus reus of defence that has been involved. Other people, as we mentioned, can play a part in the crime alongside this person, and they can be liable for it in law despite not committing the crime and getting their hands dirty themselves. For example, a person hiring a hitman to carry out their undesirable activities for them will not be absolved of any liability for the crimes he carries out, even though they themselves did not physically commit the said offence. So accomplice liability is addressed in the case of the law on secondary liability following the decision in R and Jogi, and the case of Ruddick and the Queen, 2016. The abolition of parasitic accessory liability as a basis for criminal liability, the liability of an accessory based on conditional intent, and the evidential value of association and presence, and the evidential value of an accessory's knowledge of weapons. How to select charges that involve principal, secondary, and incoherent liability, and the approach to charging group assaults, including cases of murder and manslaughter, and charging offences under the Serious Crime Act 2007, and recording the basis for charging decisions. Parties to an offence. Where two or more persons are involved in an offence, the parties to the offence may be principals, D1, or secondary accessories, D2. Each offence will have at least one principal, although it is not always possible or necessary to identify the principals. A principal is one who carries out the substantive offence, i.e. performs or causes the actus reus of the offence with the required mens rea. If two or more persons do so, they are joint principals. And when it comes to looking at identifying the different roles that people can play, we've looked at the principal and the joint principals, and these are broken down, and there's also innocent agents, and there's also the other one is where there is the issue of whether the person is a secondary party or not, as we mentioned earlier. So innocent agents it's also possible that the principal offender will not carry out the actus reus of their chosen offence themselves, but instead utilise an innocent third party to carry out the actus reus. And there are mainly two distinct situations where this could arise. Firstly, where the agent lacks any sort of mens rea for the offence, and secondly, where the agent has a defence available to them. It is possible to carry out actus reus of a crime without holding the requisite mens rea, and thus the offence committed. If you, for example, consider an example which is which I'll go through, is where an ex-wife wants to kill her ex-husband. The husband has a fatal peanut allergy, so the woman gives their adult daughter a batch of peanut brownies to take over to her ex-husband's house. As far as the daughter is aware, they are not free, and gives these to the man. Whereupon he eats one and he's killed instantly. The daughter has no idea that the brownies contains nuts, so cannot have the mens rea for the murder of the ex-husband, the intention to kill. The ex-wife, however, holds the mens rea and brought about the actus reus by using the daughter as an agent to carry out her desired act. In this scenario, the ex-wife would remain the principal offender. Secondary parties are more commonly described as accomplices or accessories to the crime. They are people who help to encourage the principal offender without themselves physically carrying out the actus reus. The help must be provided before or during the commission of the offence, as any help that comes after the offence has been completed. For example, providing the offender with help escaping will not give rise to an accomplice liability, but may give rise to liability for other principal offences. And the important case in this was, as we mentioned earlier, the Jogi case 2016. The facts of the case are, in this joint case involved two separate appellants who had been convicted for murder on the basis of joint enterprise, after a co-defendant had actually killed the victim. In the case of Jogi, he had been vocally encouraging the principal while he murdered a police officer. In the case of Ruddick, liability was based on the participation in a botched robbery during the principal murdered the victim, an act which the principal admitted. In the case of Jogi, the judge made the decision that liability as an accessory would attach where the defendant participated in the attack while realizing that the principal might stab the victim while intending to cause really serious harm. In the case of Ruddick, the judge in this case made the direction that it was necessary to establish a shared common intention between the principal and the accessory, and this could be proved where the defendant has shown to have known as there was a real possibility that the principal might intend to commit a given crime, in that case GBH or murder, and still continued with the participation in the joint enterprise. Parties to an offence in the Jogi case, the issue in this case was that the court had to determine whether the principle of parasitic accessory liability as established in Chan Wing Su and the Queen 1985 is a correct exposition of the law. It was held that the court held that in order to prove accessory liability, it was not sufficient to only prove the necessary mental element, but also the element of conduct. This could be discharged by proving that the accessory either assisted or at least encouraged the principal in committing the offence. The mental element is discharged by proving that the accessory intended to so assist as to encourage the principal. It was held that the mental element, however, is not discharged by mere foresight that the principal might commit an offence. In Chang Wing Su and the Queen 1985, it was incorrectly decided in part of equating foresight with intent. The convictions were therefore quashed in R and Collinson, 1831, 4-part and P 556, R and Smith, Wesley, 1963, 1WRLR 1200, CCA and R and Reed Barry, 1976, where the Court of Appeal were approved. 4.3, distinguish intention to commit crime from an attempt. So the common law intents, so you've got elements and defences to incoherent crimes and accomplice liability. So the elements and defences. We've got the first one is actus reus for solicitation, where it's not guilty if no other voluntary physical act. For solicitation is incite, counsel, advise, induce, urge or command another to commit a crime. For accomplice, the actus reus is aid, counsel or encourage before or during another's crime. And for conspiracy is the agreement to achieve unlawful purpose. and for attempt is substantial steps beyond mere proprietation, last act, danger, or proximity. For general intent is not guilty if general intent not present. So for solicitation, intent to ask. For accomplice, the intent to aid, counsel, or encourage. For conspiracy, the intent to agree. For attempt, the intent to do the act. But for specific intent is not guilty if specific intent not present. So for solicitation is the intent that the person solicited commit crime. So the general approval not enough. For accomplice, not specific intent crime, must have intent to aid, mere knowledge, not enough. And for conspiracy, the intent to achieve the objective of agreement, and for attempt to intent to accomplish the crime. For specific intent defences, the duress, mens rea, unreasonableness, mistake, voluntary intoxication. For solicitation, if the defence negates the specific intent. For accomplice, if the defence negates the intent to aid. For conspiracy, if the defence negates the specific intent. And for attempt, if the defence negates the specific intent. For the element and defence of merger, for solicitation, merges with target or with conspiracy. For accomplice, not applicable, so the crime is already committed. And for conspiracy, no merger, the old rule applied merger. And for attempt, mergers with target crime. So this identified the elements and defences of each crime. Intention. So intention is critical when a court decides whether or not a defendant should be convicted of a crime. Intention can be direct or indirect. We've got direct intention, and then we've got indirect intention. Direct intention is the aim of the defendant. This is essentially whether the defendant would consider his action a failure if desired consequence did not occur as a result of his action. And the leading case for that is the case of R and Mohan, 1975. Indirect intention, and this is found when the defendant may intend a consequence, although that the consequence is not their objective if it is foreseen. And that was the leading case for this, is the case of R and Woolen, 1999. And the facts in this case is it comprised of the defendant throwing his three-month-old baby to the ground in the frustration when it would not stop crying, leading to the baby dying from a fractured skull. The court accepted that the defendant did not intend to cause death or harm to the child, but that the defendant foresaw there was a risk of causing serious harm to the baby as a result of his actions. The original trial judge directed the jury that the oblique intention exists if there's appreciation of substantial risk of injury, which resulted in the jury deciding that exposing somebody to a risk of harm was sufficient to amount to intention. The case was referred to the Court of Appeal and then the House of Lords to consider whether this was the correct way to define intention. It was held that the Court of Appeal upheld the murder conviction. However, upon appeal, the House of Lords overturned the conviction for murder and substituted it for manslaughter, holding that the original trial judge had enlarged the mens rea element for murder by introducing the question of whether the defendant foresaw substantial risk. The term substantial risk blurred the lines between the intention and recklessness. And as recklessness is not a state of mind sufficient to convict a defendant of murder, it is important to keep them distinct. The House of Lords confirmed that the virtual certainty test introduced in the case of Nedrick should instead be used when considering oblique intention. However, the House of Lords also amended one word in the Nedrick test which is rather than intention being inferred by a positive answer to the two questions, it only allows the jury to find intention. This has been presumed to mean that whilst a jury are able to find that the defendant had the intention, they're not obliged to find that the defendant actually acted with intent when the offence was committed. It was suggested that this is to allow juries some moral elbow room when considering complex cases. However, the case of Ashworth argues that for serious offence such as murder, the court should be aiming to introduce a tighter definition for intention and allowing the more complex cases to be dealt with by ways of defences or partial defences. And also in regards to another case in regards to using the Woolen ruling was the case of in Aaron Hales, where the court gave different direction to that established in Woolen. Instead suggested that the jury should consider the defendant's actions before, at the time of it, and after the alleged offence. There was no need to establish foresight, because the jury could infer from the defendant deliberately reversing into the officer that there was clearly evidence that he intended to kill. This has been distinguished from ruling on the basis that the defendant had previously attempted that. Although it was not his motive to kill the officer, he was prepared to kill in order to escape. Despite the criticisms, it is clear that Woolen remains the leading precedent used when the courts and juries are considering oblique attention. Nori stated that the Woolen constitutes the last word on the direct, indirect intention for murder. Thank you for attending today's session, and thanks for your patience, and I will see you in the next session, which is Learning Outcome 5. Please refer to Moodle for any additional cases or any additional reading. Thank you for attending.